A proposed MCLE rule requiring 10 hours of CLE per year for every Maryland attorney is currently before the Court of Appeals of Maryland. An MSBA membership poll disclosed 70% of MSBA's members oppose MCLE. This controversial issue was the subject of a lively senior lawyers section program on October 27th. Proponent Paul Mark Sandler and his opponent, the Honorable M. Albert Faginski, debated the pros and cons of MCLE before an audience of close to 50 senior lawyers.
So the purpose of this meeting is to acquaint as many people as saw fit to sign up with what is proposed. And the long and the short of it is that pending before the Court of Appeals are new rules that would require mandatory continuing legal education. And it obviously will affect each and every member of the bar with limited exceptions. So without further ado, I would turn it over to Mr. Sandler.
Good afternoon, everyone. I'm very pleased to be here to talk and discuss and debate something that's very important to the continuing education of the members of our bar. It's historic, but it's also relevant and prevalent today, discussions about continuing legal education. There's so much going on. There are private companies that come into various jurisdictions, charge a lot of money for half-baked programs. There are requirements by our own law firms in some instances to be current on some of our specialties. But I would like to talk to you this afternoon, if I could adjust this, about why this group, and now I'm a member, so I could say our group, should support continuing legal education on a mandatory basis. First, to round out the history, Rob, if I could. For many years, it has been kicking around Bar Association and the Court of Appeals. And I will either credit or I will blame Mr. Sykes for what's occurring now with CLE, because he and I and our spouses traveled to Annapolis about, I think, 2 years ago, for the Bar Foundation meeting. And I gave a talk at that time, and I was very clear and respectful that I was embarrassed that the Maryland Court of Appeals had not acted on adopting MCLE. And of course, sitting in the front row was our chief judge, and he was giving me his views that maybe I shouldn't be saying this, but I did. And then I wrote to Judge Wilner on the Rules Committee, and I said, it's time to start being serious about this, Your Honor, and it was a respectful letter. I sent the letter, I remember, at 3 o'clock in the afternoon. I was in my office at 8:45, the phone rang, it was Judge Wilner. And he said, well, you know the history of this. I said, I do, and I know that the Rules Committee blocks it year after year. You will not let it come out. He said, no, that's not true. And then he mentioned the names of some other lawyers who were involved. And I said, well, I'd like to come down and talk to you about it. He said, well, we'll schedule you. And he did. Went there. It was the same. It's just exactly as what I would have envisioned. It was just, there was no resonance by anyone on that group. A few of the younger members, but it just wasn't making progress. At which point, and this is fortuitous, the chief judge formed a permanent commission on professionalism, and Lynn Battaglia, Judge Battaglia, chairs that commission, and asked me would I chair a committee on MCLE, because she was of the mind that its time has come. So I did not hesitate a moment, despite Mr. Sykes' chagrin, because he was very clear to me that he did not approve of my talk at the Bar Foundation, because he had very strong views that MCLE ought not to be invoked in Maryland. But nevertheless, I proceeded, and in chairing the committee, I developed a rule. I proposed a rule. The rule is so, what can I say, mellow, calm, gentle. It's not an intrusion. All it says, the key point is every Maryland lawyer will have 10 hours a year of continuing legal education. 2 should be on professionalism. But 5 of those 10 hours, folks, 5 of those 10 hours could be right here. This could count. It could be on a teleconference. It could be on approved webcast. So this burden on the membership is an ancient argument that has outlived its purpose because of modern technology. So this business of causing burdens is not, it's a red herring. So that's the rule, and there are also in numerous ways to opt out. In fact, the rule that I invoke with the Commission's blessing and support is so minimal that the judges around this table should wonder why they have more stringent mandatory continuing education from the Chief Judge than we lawyers, and they're right to wonder why. But nevertheless,
They need it more.
nevertheless, you'll have your turn. Nevertheless, the rule is now under consideration. So what is the status? Because Rob said no one knows, but I do know the status, and I'm happy to share it with you. So our commission has postulated a proposed rule, and it's before the Court of Appeals, and the commission has been advised that the Court of Appeals and the Maryland State Bar Association are going to undertake with the Bar Association one more survey. The court is interested to know what are Maryland lawyers now doing with regard to their self-education. Are 80% of the lawyers trotting down to Mcle or Maryland State Bar Association programs or not? What are we as lawyers doing? When that survey is complete, I then understand the public hearings or the hearings will take place. So that's a little bit of the history, how it got started, and then just so you know that Judge Battaglia and I and others have been going around the state speaking to state bar association groups and talking about CLE and engaging in dialogue. So I now beseech you to consider the following, and I would say it formally. Resolve, the senior lawyers section of the Maryland State Bar Association should support MCLE in the state of Maryland. And there are 3 primary reasons. It's very simple. The first, it benefits us as lawyers to be current, to be stimulated, and to be on the cutting edge of the issues we confront for our clients. Because the better we are, the better job we do for the people and causes we serve. The second reason is that it benefits the profession. Are you not embarrassed when you go around the community, if you do, and appreciate that when you get your hairstylist, for those that have it, had to get certified? Your plumber, when the boiler goes up, has to be certified? The doctor that you go to when you need your emergencies attended to, she has been certified. She takes courses. She is required to remain current. The third reason is that it benefits the community at large. To have confidence in Maryland lawyers as professionals with the dignity and the determination to maintain the highest standards. And appearance is, in this instance, extremely important. Those are the 3 main reasons that I urge you to consider when you think about this. I recognize that arguing and debating CLE is somewhat akin to arguing or debating politics or religion. Most of us at this stage of our lives have formed certain tenets, certain beliefs. We adhere to them while we're patient and listen to the views of others. Simply say, I hear you, but, and keep the answer to yourself. But this is a forum where I'm asking us not to keep our answers to ourselves because I think it justifies some discussion. So now I've suggested the 3 important reasons why. Let me share with you some of the thoughts that might be going through your mind. First of all, can you really force someone to learn? Isn't it silly to say you must go to this course? Because after all, if someone has the intellectual curiosity and the aspiration and dedication to improve themselves, would they not do that on their own? And the answer is no. Because the Peter Principle, what you plan to do tomorrow is overshadowed by what we must do today. So no one gets there. I suggest, Mr. Sykes, there are 3 layers or levels of individuals who practice law vis-a-vis CLE. There are those who will go on their own. There are those who will not go on their own, but if you say you must do it, they will go with alacrity and gain something. And then there may be the 3rd category of those what I'll call dunderheads. Maybe they shouldn't be lawyers in the first place. Maybe that's too strict. But they will go and read the paper or say the Blackberry prayer all through the program. But what about that middle level and that first level? And if 10 out of 100 attend the program that they would not have attended, but become ignited or stimulated to innovate or develop or help their clients in a way they would not have, the mission has been accomplished. I share with you the idea that burdens of economics are not a valid objection because of what I alluded to earlier, which is modern technology. Now, today, in today's world, and we have to think that we really, as senior lawyers, are ambassadors from our previous generation to the next generation. We have to have the vision to see what's going on in the bar today with young lawyers. Computers, iPads, iPods, Facebook, LinkedIn, this is second nature to them. Why today, 5-year-olds can fix computer problems that 65-year-olds are fearful of. So the world is changing. And with this changing world comes the ability to interact and connect. So CLE can be done while we're having lunch by ourselves with our feet up, watching Mr. Sykes or Judge Kaplan or Judge Fader discuss a particular aspect of law. It's that simple. So to say it's an economic burden is not valid. And if it is an economic burden, it's minimal and it's required as an emblem of being a lawyer. Because after all, any lawyer today worth the name aspires, as he or she proceeds through and passes through the ranks of the profession, to leave our profession better than when he or she arrived, and to leave our profession as a more perfect instrument of human justice. And to fight these causes as lawyers, we must be armed with the intellectual armor to combat those who think that we are incorrect and our cause is unjust. And without education, we cannot accomplish this. And if we sit on our laurels and shuffle back and forth, not focusing on what those who come after us are challenged to do, we've missed it. And why should we be alone, everybody? You know, there are only four states in the whole country that don't have CLE. And guess what? Who sits in the center of the 4? Our Bar Association. And it's shameful. And I say it again and again and again, it is shameful that the Maryland State Bar Association has taken the position that it has taken. And I'm a member of the State Bar Association. I fought hard to create the litigation section of the Maryland State Bar Association. I met the same types of obstacles. Judges on the Court of Appeals then wanted to make the litigation section part of the judicial administration. They couldn't see what then the younger generation was trying to accomplish and what it needed to get accomplished. And I've been on the Board of Governors, and I've been very active, I've never been ashamed of our State Bar Association. I am now. I don't want to be a minority jurisdiction and be viewed as anti-intellectual. And I want us to think about it. Now let me share with you one last point, and then I'll yield to Mr. Judge Figinski. And that is this. To grasp hold of human nature and understand the dynamics of where we are is essential. If you stand for the proposition that our bar must have the highest standards, if you recognize that education with to keep up with the fast pace of the law, to keep current, is essential, or we are in trouble and our clients are in trouble. The only issue remains is, why should we not self-impose on ourselves the most minimal requirement that all of us can pledge we will be current? And to say that we once passed our law bar exam and that no one can tell us what to do, is not to live in the 21st century. And I will not be comfortable if the Court of Appeals suggests that MCLE should be aspirational. To me, that is a cop-out, and it is a sign that I do not want to see or even hear of if I want to be proud of being a lawyer, a full professional, willing to commit myself to be burdened with 5 hours of hearing Judge Fader talk to me about family law. I won't yawn, I won't bring other material, I will listen and I will learn, and my clients will benefit. Thank you.
Only those people old enough to be in this room can remember that I was a judge, because it was a mere twinkling in the year 1980. I was there for 11 months, and the citizens of Baltimore, by 17 votes, did me a great favor. Because I'm 72 years old and I'm not senile. And I'm not embarrassed. I'm not embarrassed at all that there is no mandatory continuing legal education in Maryland, and if I have any breath in me left, if and when that comes before the red-robed wonders, I'll be there to tell them, hell no, not now, not tomorrow, never! And I'm going to say why. Lincoln, there's a Lincoln picture which appears in many lawyers' offices. A lawyer's stock in trade is his time. When you take from me my time, mandatorily, you take from me something that is my stock in trade. And if you took it from a business, that would be called a theft. Now, I yield to no one on the amount of work that I personally do to keep current. I yield to no one on the advantages of education. But I can tell you that you can't force a person to learn. You can only bring learning to those willing to learn. Now, I'm not interested in forcing everybody to come to a session. Now, Mr. Sandler tells you that you could come to a meeting like this and you could get credit. Baloney! The courses have got to be pre-approved. Pre-approved. We've got to have syllabuses and handouts. Now, I spent some time doing this little escapade today, but I don't have a syllabus or a handout. I have a pack. I came to the bar in 1962. One of the first things that I did was to go with my father, who was a lawyer, great lawyer, to the Orphans Court of Baltimore City. We were contesting a will by a person, allegedly made by a person who had long been his client. And we were brushed aside by the Orphans Court. But Rig Baldwin of this association picked up the ball. Lawyers went to jail as did a few undertakers, because when people died without a will in certain areas of the city, they made wills for them. And people lost money. It was a shameful experience. And the bar came to the rescue. It created something called the Client Security Trust Fund. There was a need, the need was filled, and the need solves the problem. If there's a defalcation, there's money to pay those who lost. Now, what is the need? So we don't feel bad with respect to the other 46 states? Has there ever been someone taken to the grievance commission for incompetence? The answer to that is rarely. And let them do it. Then you don't read the same reports I read.
Correct.
This is another example. Oh, the proponents' views on need have been expressed in writing. It was in a publication called The Maryland Litigator. In fact, I think Mr. Sandler had a part in writing it. In responding to something that says there is no evidence that Mcle improves the quality of attorney performance, they say, the short answer is that there is no evidence that Mcle does not improve lawyer competence. You guys heard, or you ladies, heard of somebody named Axelrod? The phony that sits outside of Obama's office, who put the same answer to a reporter's question when they asked him to tell us what evidence you have that foreign companies are contributing to these political ads. And Axelrod said, I don't have any evidence, but do you have any evidence that they're not? It's the same statist approach. I'm all for reporting, telling people what I've done. I'll let them come and sit next to me every morning when I get to the office before 8 o'clock and don't log into worrying about what my office thinks or needs until about 9:30, because I've, in that course of time, checked a whole area of research. The Court of Appeals, the federal courts, they're not slipping any opinions by me, but the ones I see coming out don't get improved by the 20 hours they spend in continuing education required. Now, I've also had the experience of going to teach, imagine me teach the judges how to write opinions. Well, that I had to go with a syllabus and a prepared remarks. Well, they didn't ask me back this year, but they're still using my syllabus and prepared remarks. I'll never forget this. A judge, unnamed, came up to me as we started in the morning. We took a break in the morning, and he says to me, Al, when are you going on? I said, I'll be on right before lunch. He said, good, I'm leaving right after. The program went on to 3 o'clock. Now, I also have had, in the course of my experience, represented some of these healthcare professionals who have been required to go to these continuing education programs. Their experience does not recommend this kind of mandatory nonsense. I would hope that the Bar Association would not indulge in yet another poll. Let me tell you my view of history about this subject. In 1995, the Bar Association was moving forward one mandatory continuing legal education. I didn't like it. I liked it even less then than I do now, because I haven't got much more to go. I wrote a 3-page letter on December, my eyes are gone, December 20th, 1994, to the president, the incoming president, and some other folks, talking to them about what I thought about continuing education. I'm not going to trouble you with the 3 pages. I'm going to trouble you with the last paragraph. In sum, a proposal for mandatory CLE, admittedly without empirical evidentiary basis, should not be rammed down the throats of the rank and file of the bar. The membership should have an opportunity to verbalize their misgivings, if any, and the putative product should be subjected to a plebiscite. In the absence of a vote of the rank and file, the proposal is nothing more than the bold intrusion of a bevy of platonic guardians. I stand on that. They've had their plebiscite. They don't like the answer because they're not going to look so nice with the other states. I talked to one of you in a hallway, and I told you what they could do with that problem. I won't repeat it here. This is an idea whose time has not come, and I hope never comes. But you know something, ladies and gentlemen? There's not a whole lot we can do about it. All we can do is stand and say, no, there's no evidence of a need. So, a lot of us do to take care of the problems on our own. But we, at the bottom end, will have a result by the Court of Appeals. The Court of Appeals will decide, and they will be last, not because they're right, but because they're last. All any attorney can hope for is an opportunity to be heard on an even playing field. We haven't had that even playing field because the Bar Association in the past has bought into this subject. They don't like the plebiscite. And they keep publishing things that say, it's coming, it's coming. If the Bar Association were Paul Revere and went to the suburbs of Boston to announce that the Redcoats are coming, his message would not be, get your muskets ready. His message would have been, set the table and let's have nice. I don't think that's what we have a Bar Association for. I think that Bar Association needs to stand and be heard. That's all we have the opportunity to do, is to be heard. And if the Bar Association is not heard based on the plebiscite that was taken, it doesn't serve our purposes. But if they don't go, if they have, for whatever reasons, a desire perhaps to keep Mcle, which they now own, going, for whatever reasons, if they decide to go forward, then I'm going to go to Annapolis when they have that open meeting, if I can still stand on two bad legs with only one eye, but with one big voice, and say, you haven't proven your case. And until you stop being Axelrod and have at least anecdotal evidence, don't impose on us. I thank you for your time, and I urge you to remain vigilant. Now, one last word. 2 hours of professionalism. How many years of experience is sitting in this room? How many years? I've been doing this stuff for 48. I came to the bar and saw people that I venerated sitting at this table. And they want us to take a professionalism so that we can go and bow nice and are not advocates anymore, but do conciliation. Professionalism for this crowd? No. You know, they've got Rob has told you that they've got a package of material up in their Mr. Carlin's office. And there's some very good ideas in that package of materials about different ways of doing this to accomplish this end. In fact, back in 1995, a lawyer who I don't know from Montgomery County wrote a letter saying, anybody who's been at the bar for 25 years doesn't need to do this. And I think at least that's right. Don't give up. Don't rely on the Bar Association. Be vigilant. And I'll be there, hopefully, if and when the time comes. And I urge you all to be with me. Thanks.
About the bar in general. And we're not talking about us. Because when Mr. Viginski says that we don't need it because we've been around for so long, well, we could be teaching. And we can be writing. And we can be studying still. Because sometimes, as you get older, you forget. And you don't recognize that the law is changing. And you're still in divorce court asking for a vinculo or whatever, and that's long gone. So it's not, it's more applicable to older lawyers than younger lawyers, if you want to really face it. But I will also say to you that Mr. Viginski has 3 reasons why MCLE should fail. First, he says it's theft, because we're stealing people's time. Now, come on, is that real? Every day of our lives we have to do something. I could sue my wife for stealing my time for billions of dollars whenever she tells me to take the trash out when I'm trying to get an article completed. People that sit down and pay their taxes can sue the government because they're stealing time. When we commit to being a member of the bar, we invite regulation that's reasonably related to the goals that we achieve. That takes, to me, solves the theft problem. The other issue that Mr. Figinski seems to be very enthused about is that there's no anecdotal evidence about what's going on in terms of whether continuing education can really improve us. I think common sense, whenever I go before a jury, whenever you go before a jury, I always talk about common sense because I think that's really what controls much of what we do. Is there anyone in this room, I'd like to see your hand, who doesn't think, like, or understand a common sense approach, that the more education you have about a particular field, the better equipped you are to handle the problems and see beyond your nose to spot issues that in some way can be beneficial. If there is a hand, I'd like to see it, because I will be shocked, because I know most of you. It's impossible. So when Mr. Figinski talks about that, he just wants you to put your common sense aside. It's ridiculous. Finally, he talks about a plebiscite. What does that mean, a plebiscite? Should we have a plebiscite as to whether or not we should have race discrimination? Should we have a plebiscite as to whether short people should be allowed to go to court? There's certain aspects and basic tenets we all have that right and might don't match. Aristotle, Plato talked about it thousands of years ago. I mean, might doesn't always make right. And that's why we do have a Court of Appeals. And there's a process by which these judges are appointed. And therefore, the idea of taking a plebiscite to decide whether this should be a rule or not, I don't accept. Is it important to hear the views? Of course. As far as another survey is concerned, I think it's a very intelligent approach, because I do think the Court of Appeals, in seriously considering this, would like to know what is the status of Maryland lawyers today with regard to CLE. Finally, anecdotal information and evidence. That's what Mr. Figinski wants. I am going to play for you an interview that I arranged by fortuitous circumstances of a lawyer in Indiana about CLE and the reaction of the bar. If you will, it's about 3.5 minutes.
You represent somebody who took the Colts?
The gentleman I see in the corner having lunch, a lawyer from Indiana. Let's talk to him about CLE and pose some questions to him to gain an idea about how Indiana lawyers confront MCLE. Good afternoon, my friend. Could you tell us your full name? I'm reluctant to give my name because I have to protect the innocent. Well, sir, can you tell us whether or not you are a lawyer? Yes, I am. I confess. What state do you practice law? Indiana and Iowa. Well, that's very interesting. Let me ask you, do those states have what we call mandatory continuing legal education? Indeed they do. Why are you asking me these questions anyway? I'm trying to have my lunch. Well, I'm going to be involved in a debate with a very famous judge and lawyer in Baltimore, and I wanted to have some anecdotal evidence of how lawyers in other states deal with mandatory continuing legal education, and I have to see you and need to get some answers. All right, well, hurry up, because I told you I'm busy having lunch. Ask me a question. Okay. First of all, when mandatory continuing legal education was first presented, what was the reaction of the lawyers in the various states that you practice in? Well, it was mixed. There were many lawyers who were in favor of it, and there were many lawyers who were opposed to it. Well, how is it then that the courts of those states passed a rule requiring MCLE? Well, we have some of the wisest judges in the country. They know what the bar should be doing, and the lawyers, the leaders of the Bar Association, they understood what our obligation was to ourselves and the communities. Well, what obligation are you talking about? Well, I'm talking about the need to improve ourselves as practitioners, because the sharper we are, the better we can represent our clients. As far as the community is concerned, we owe a responsibility to the public to demonstrate that we know how important it is to be current and fulfill our duties. Well, in conclusion, how are lawyers now reacting to MCLE? Very favorably. It's not very burdensome. We only have 20 hours a year to fulfill, and everyone does it. Well, does everyone go to classes together? No. We have opportunities of podcasts and all those technical advancements that we didn't have years ago, and everybody seems to do it And most of us enjoy it, look forward to it. Why do you look forward to it? Because it gives us an opportunity to network with friends, interact, and improve our own abilities. After all, the practice of law is still a noble profession, you know. Well, thank you very much. I appreciate it. Are you sure you can't tell us your name? Absolutely not. Now go away from me.
That lawyer who gave that anecdotal information is a very good lawyer, tries very hard.
Thank you, Dr. Bergen.
What?
Yeah, Edgar Bergen. He said Edgar Bergen.
No, no one would give me an interview, quite frankly, so I interviewed myself. So that was me playing the Indiana lawyer. But the point is, Judge Figinski, that obviously there are two sides to all of this. But I do think,
the whole bar association on your side.
but I do think that those who understand the problem and recognize that perhaps the rule is not aimed at us, but those that don't have the talent and the dedication that some of us do, those who could be led to the water and could do their drinking. So I leave it to the future days of discussion and debate, and the time that will come when the Court of Appeals will hear all of this, and certainly will hear from you. Thank you.
Two things. Don't be beguiled about how easy it's going to be. They require the courses to be approved. They require, this would not count. Number two, I am glad that Paul owned up to the fact that he did this himself. Because if he had taped somebody in Maryland without his approval, he would have committed a crime. And how do I know that? Because a long time ago, I helped write both the Federal Wiretapping Act and the State Wiretapping Act, both of which have been bowdlerized by those wonderful courts who we have to look to for our salvation. Thank you.